1、2、3、4、5、6、7，七啊！連埋我夠，夠啦。陳邊個都喺度睇。
咁我哋講咗下次開會傾咩先請佢入嚟。
唔係，我而家仲要讀埋啲嘢㗎，係啊。好，各位
Members, welcome to the panel on administration of justice and legal services, and we have formed the quorum, so I'll call the meeting to order. So please take a look at CB4 65A/1415 bracket 01 and bracket 02 papers, and they are the list of outstanding items for discussion and list of follow-up actions. We would be deciding on the items to be discussed in the next meeting. The government hasn't raised any proposal for our discussion, so we suggest that there are two items to be discussed in the next meeting. The first one is that items 2 and 16, and that has to do with legal education and training in Hong Kong. And on the meeting at the 16th of December 2013, we have discussed that item. We can consider asking the DOJ to brief us on the work of the Standing Committee on Legal Education and Training, because they've been conducting a study all along, and to update us on the progress of their study. And also, in the last meeting, we have invited only the deans of the three School of Laws to speak to us. So we hope that we can invite more people to talk to us, especially the representatives from the Law Society and the Bar Association. Especially the Law Society has been conducting an independent study. We would also hope to invite some students' representatives to come, and also those who have been specializing in the subject of legal training, some professors perhaps, and we would like to invite them over to give their views. Dr. N. Chang, Madam Chair. Outstanding issues of discussion. Recently, we've had community views saying that for some sentences there might be problems. And some people also said that the sentences handed down by the judges are too light. And some have been suggesting that individual circumstances have to be taken on board. Some people said that people are imprisoned for 2 months for stealing a bar of chocolate. But then for others, who have hacked into the computer system, they are not jailed. How come that this is the case? Should we set aside a time to listen to the views of the legal profession on such cases, on sentencing particularly? Should we be looking further into sentencing? Is the sentencing too light in certain pieces of legislation? Should there be a review, Madam Chair? Yes, I've heard your views. All right, we'll look into that to see what is the appropriate time to discuss that. I think this is an issue of community concern. Mr. Abraham Sheikh, Madam Chair, you discussed the legal education training in Hong Kong. I hope that students can also be invited along, especially those who can't enroll in PCLL, and also paralegal professions, paralegal practitioners. They may be in that job for their entire life. Perhaps they can be asked to give their views on legal training and education. I support that item to be discussed. Yes, Dr. N. Zhang has raised this other item, so we'll look at whether there is an appropriate time. I think that's worthy of our discussion too. The second item is raised by the Vice Chairman. He has written to us. He says that he would like to talk about adjustment to scale rates, the rates for calculating legal costs for solicitors and their staff on party and party taxation. The last revision was made at by the Registrar of the High Court in 1997. I think that warrants our attention and is something of great concern to the legal profession and also to the community as a whole. So I think that should be included in the next meeting. If time permits, perhaps we will see whether Dr. Zhang's item should be discussed in the next meeting or the next meeting. Thank you. Now we'd like to go to the agenda proper today. Mr. Raymond Wong. Rules of Procedure 83A. Members, please be reminded that if you have a direct or indirect pecuniary interest in the subject to be discussed today, you should disclose the nature of that interest before you speak. All right? Let's move on to the item on provision of legal aid and assignments of lawyers to legally aided persons by the Legal Aid Department. And I would now like to invite the administration team in. In the last meeting and also this meeting, we have circulated paper CB4658/1415-03, and that is the administration's paper on provision of legal aid and assignments of lawyers to legally aided persons by the Legal Aid Department. And the second paper is CB4658/14-15-04, and that is a background brief prepared by the Legislative Secretariat. First of all, I would now like to call upon the HAB. Now, I would like to call upon the Deputy Secretary for Home Affairs, Mr. Laurie Low, to brief us on the provision of legal aid and assignment of lawyers to legally aided persons by the Legal Aid Department. And then I would invite the Bar Association's representative and the Law Society's representative to speak on this item. First of all, Mr. Laurie Low. Thank you, Madam Chair. The topic today is provision of legal aid and assignments of lawyers to legally aided persons by the LAD. We have submitted a paper to the panel and set out a lot of detailed information, so I will be highlighting the salient points. We've discussed this subject for many times in this panel. Under Hong Kong's current system, legal aid is an integral part, and our policy objective is to ensure that no one with reasonable grounds for pursuing or defending a legal action is denied access to justice because of a lack of means. And the LAD acts in accordance with the Legal Aid Ordinance, LAO. Under that ordinance, irrespective of whether it's a civil or criminal cases, I will provide legal representation to the qualified or eligible persons. Now, before they do that, the legal aid applicant must satisfy the means and merits tests as provided by the LAO. Under the OLAS, whether it is a civil proceedings or criminal proceedings, the FEL is $269,620 Hong Kong dollars, and for SLAS, which is targeted at the middle income groups, the FEL is $134,810. To ensure that those applications with reasonable grounds be granted legal aid, the Legal Aid Council at the LAD will conduct a means test, or rather merits test, and according to merits test, they will consider the background of the case, the evidence available, and the legal principles applicable to the case to determine whether legal aid should be granted. In our paper, we have explained that in recent years, the government has implemented a number of measures to improve the legal aid system, including the increasing the FEL for OALS and SLES, and we have also expanded the coverage of the two schemes. And actually, in the meeting of this panel last month, we said that we would propose amendments to the legislation to adjust upwards 7.7% of the FELs of all LAS and SLAS in accordance with CPIC. We have also expanded the scope of SLAS a couple of years ago, and the LAD colleagues are now trying to accumulate the experience in dealing with the cases covered under the expanded scope. And we have also invited the LASC to further review the scope of the SLAS, and we look forward to a new round of recommendations from them. And also, in response to members' questions last time, we have tried to make comparison with over jurisdictions, and that is set out in paragraphs 11 to 16 of the paper. You can see that compared to other jurisdictions, you can see that Hong Kong's legal aid system, in terms of the FEL, and also the calculation of the FEL, and also the coverage of the schemes, compares favorably with other jurisdictions. Another subject of interest to members is assignments of lawyers to aided persons. In accordance with Section 13 of the LAO, it is stated that the DLA, Director of Legal Aid, may act for the aided person through the Legal Aid Council within the department, or assign any lawyers in private practice who are on the legal aid panel selected by either the aided person if he so desires.
So no matter what kind of case that is, the LAD would always bear the interests of the aided persons in mind, and it would assign lawyers accordingly. The LAD has also formulated the relevant guidelines for assigning lawyers. This has been passed by the LASC and now is uploaded onto the LAD website. And the public has been very concerned about improper touting or jeopardy activities. The LAD has consulted the LASC and the two legal professional bodies. In September 2013, the LAD has introduced a declaration system for legal aid cases. The system seeks to ensure that the nomination of lawyers are made out of the aided person's own free will, and they will not have agreed to share any damages, property, or costs which they may get or retain in the proceedings with any persons, including the lawyers nominated. Corresponding clauses are also set out in the assignment letters issued to lawyers as assignment conditions. The LAD also has a number of monitoring mechanisms concerning these kind of assigned out cases. A departmental monitoring committee chaired by the DLA is established to evaluate the performance of assigned lawyers in handling legal aid cases and the number of legal aid cases assigned. And also, there is a mechanism for making representations. If anyone believes a person should not have been granted legal aid, he or she can make a representation to LAD. If the representation is verified after investigation, LAD will discontinue the relevant aided person's legal aid certificate and refer the matter to the police for follow-up action if necessary. In order to enhance the transparency of the system, in 2013, a corruption prevention group has been set up by the LAD and the ICAC. And ICAC has recently completed a study on LAD's assignment system for lawyers and experts and has submitted its report recommendations to LAD in January 2015. LAD will carefully study ICAC's reports and recommendations. Chairman, this is my briefing on the paper, and we would like to answer members' questions and listen to your views. Thank you, Mr. Low. Now let us invite the Hong Kong Bar Association's representative to speak. Who will speak, please? Mr. Barreto.
There are a number of separate topics to be dealt with, and we'll be dividing up the topics between us. Firstly, on the general points, I will be making some remarks on that. Nicholas Pirrie will be dealing with the financial eligibility limits points and the statistics. Robert Pang, Senior Counsel, and Valentine Yim will be dealing with the checklist of the SLAS reform position. I think Mr. Pirrie and myself will be dealing with the loopholes in the declaration form for the assignment system. So there's a number of discrete points to cover. So just generally, to start off with, I looked at my speaking note for the last time I came, which was June of 2014. And at that time, I asked, that was in June 2014, what had happened, or what had been achieved since the previous meeting of a year before. And basically, not much. So what I said then, what has happened to the package of reforms put forward in the previous 10 years, from 2002 to 2012? What is the SLAS reform timetable now? There's no timetable. The papers amount to wait and see, but how long will we be waiting, and what will we see? What's the vision? No timetable, no outcome, and yet they're continuing shocking figures for unrepresented litigants in our civil courts. That was what I wrote in my speaking note in 2014, a year ago. And because of the lack of action, the Bar will refer this panel to the paper which has been in front of you since 2012 and also was part of the bundle before this panel on the 24th of June 2014, which was LC paper CB in brackets 4854/13-14. This thick document had a number of had a lot of work in it, and in particular it has the Bar's statement of 26 September 2012. Enclosure 1 of that statement of 2012 is a checklist of the reform position for SLAS, and that itemizes quite neatly the various things that were proposed for the improvement and expansion of SLAS over the decade up to 2012. And basically there were about 14 items for SLAS reform, of which we noted then that about 4 were partially in hand, 4 out of 14, which was not impressive, and how some of the 4 which had been achieved were only partial in nature and did not do justice to the full nature of the increase in SLAS which had been suggested over the many years. And just by way of background, those 14 proposals for the improvement and expansion of SLAS were the result of a huge amount of work by many, many people, and some of those people were also in the Legal Aid Services Council at the time, and for a long time, and it also included, of course, the solicitors branch of the profession, and many, many others. So that was like a consensus paper, if you like. It led to a vote in this panel in 2011 in which the panel supported a whole package for SLAS reform. It was actually called the SLAS reform package because one interleaved with another, and they formed a useful way forward. Of course, we welcome the minor improvements which have taken place, but we really do think that it's time to get on. So, a year later from last time, I'm asking the same thing. The LASC is going to present, we're told, a new round of recommendations to government. We're now being told that we will be consulted, because it wasn't actually apparent in the papers, but we welcome that we will be consulted. But we wish to be consulted before it's too late, before recommendations are set in stone. And we need to know what's going on, and we would like to know what the timetable is, because the years and the years and years are going past. And access to justice for many remains as remote as ever. So we commend the panel, therefore, to that checklist in that document I referred to. We haven't rewritten it. We don't want to waste paper because it's set out there pretty clearly what the position was back in 2012 or before. And we await the LASC and government's response to these unmet needs to access to justice over the passage of years. Now, just to remind members of this, two of our group here will briefly go through that checklist, just so as to remind members of the 14 items. I've left it to them as to how much detail they go into. I think perhaps at this stage just a matter of giving the headings so that members remember all the different topics which have had, each one of them, quite a lot of work done on them. So if I'll just hand over to my colleagues briefly.
Okay. So, Mr. Robert Nicholas Perry, please.
Yes. Madam Chairman, thank you for allowing us to come along today. I think what we should be looking at is the effect of the financial reforms which took place in 2012 and 2013. You should first remember that the substantial increases in ordinary legal aid services didn't come about for about 9 years, and you should have that clearly in mind. And that has produced the financial eligibility limit went up 53%, and it has produced, so far as we can see, very little annual change in the take-up of ordinary legal aid. So that covers both criminal legal aid and civil legal aid. And so far as the SLAS scheme is concerned, the financial eligibility limit went up 300%, and it has produced a 50% increase in uptake of supplementary legal aid. So if you have those figures in mind. And writing to the Registrar of the High Court, as we did recently, you can see that so far as ordinary legal aid is concerned, there's a very high percentage of unrepresented litigants, which show you dramatically their continuingly unmet needs. In civil appeals, the figure in 2010 was 37%. Today, it's 200. In 2004, for the year 2014, it's 20%. Criminal appeals, 51% in 2010, and the figure is marginally lower today, 48%. Civil trials, the figures are much the same. Tribunal and masters applications, the figures are still at 63 or 61%. Appeals from magistrates' courts unrepresented, 59% in 2010 and 56% today, or the last year. Civil trials in the district court, 53% in 2010 and in 2014, 58%. So those are the main features. So that shows you that ordinary legal aid, OLAS, is having no impact at all. And the increases were 53%, and the figures, when you look at them, actually some of the figures decline year on year. So it's quite clear that the limits need to go up substantially again. There are repeated calls from judges who sit in the Court of Appeal, they're presented with a box file, 40 box files, when 2 would do. And there are repeated judgments saying, why wasn't this man given legal aid? And we know that they're talking about increasing the district court limits, and if the same figures are true for civil trials in the district court, well over 50% of those trials will have an unrepresented party. So that tells you 50% in those 2 sectors alone are not getting access to justice. In civil appeals, civil trials, you're talking about 30% unrepresented parties. So we wish to urge that this panel recommends that we have a substantial financial review so far as ordinary legal aid services are concerned. And you could just look at that in comparison with the SLAS uptake, 300% increase in limits and a 50% increase in uptake in SLAS. I know that the SLAS is slightly expanded, but until we see the figures, we don't know. So that is the position, Madam Chairman. This is why we're pressing for very substantial increases in the final eligibility limit. Thank you.
Thank you, Mr. Rob Nicholas Perry.
Now let us listen to the representatives of the Law Society who would like to speak, please.
Basically, all along, the position of the Law Society is quite similar to that of the Bar Association, insofar as the need for reform by the increase of files, by expansion of the scope of the SLAS, and so forth. And in fact, as early as 2010, I believe we have a submission paper submitted to the panel at the time, and I think we maintain on the 5-yearly review. I think the Law Society's position has not changed. I would say that I wish to echo the sentiments of Ms. Barreto that the legal department has been dragging the feet, and so far not very much has been done since the last meeting in June 2014. I believe I was there as well. The LASC is supposed to make some proposal on the scope of SLAS. So far we don't know what's the position. So not much can be achieved in this meeting, I suppose. And also I want to further stress that there's no timetable laid out, as mentioned by Ms. Barreto. I think that is quite vital. I think that's all I need to say for the Law Society.
Thank you, Mr. Yang.
So it's time for members to raise questions. 4 members would like to speak. Mr. Raymond Wong, Dr. N. Zhang, Dennis Kwok, and Tang Ka Piu. Each of you will get 5 minutes. Mr. Raymond Wong first. Thank you, Madam Chair. The objective of legal aid is to ensure that anyone with reasonable grounds for pursuing a legal action is denied access to justice because of a lack of means. But the legal aid department has been very progressive in its ways and means, ways of doing things, and they've been deterring applicants to make legal aid. Let me cite a few examples. For example, in the means test, they are asking the applicants to provide proof of their support to parents. And some people have failed to do that, and there has been a delay in their application. We know that the means test is a statutory requirement, and the legal aid department must ensure that public funds are spent properly. But if you're asking people to provide proof of their support for their parents, I think this is not very humanistic. And if the government or the LAD can deal with it on a discretionary basis, then that would be best. Second, and the legal aid service can be suspended, cases can be suspended for 40 days, so that time will be allowed for the legal AD to vet the cases. But then the LAD will first do the means test before the merits test, and it usually takes over 40 days, and sometimes the cases, for some of the cases, 3 to 4 months, and that leaves the applicant with the situation that they have to deal with the cases without legal representation. And it's very difficult for applicant to get an application endorsed. If the applicant makes some mistakes in the application, then he may have to withdraw the application, and his interest is affected in vetting legal aid applications. I think the LAD should at least provide some sort of legal representation to the applicants, and perhaps ask the court to postpone the application or the cases. I think the 40-day requirement should be extended. I mean, these 40 days should be extended. I hope that you can give us some figures on civil cases, criminal cases, on the time you take to vet applications. Third, we note that the LAD's council have not been dealing with cases seriously. Let me cite an example related to myself. My former assistant applied for judicial review to overturn some decisions of the Legislative on election mail. And that has to do with a lot of political parties. For example, the DAB and the Democratic Party are trying to stand for seats in the super seat. And then some people are standing for election in the direct election seats and not the super seats. And these other people, the latter people, get 2 chances of sending their mails, and we don't think this is a fair arrangement. My former assistant applied for judicial review, and the LAD has recommended James To and Albert Ho to be the assigned lawyer. I think this is ridiculous, because they have an interest in the matter. Albert Ho and James To from the Democratic Party have been recommended as the assigned lawyers. This is so very ridiculous. Well, it shows a lack of common sense. You don't know anything about politics. The case is very obvious. That has to do with political elections. And the LAD colleagues don't seem to understand who is pitting against whom in an election. So from this example, we can see that the LAD, is not very smart. The 2 recommended lawyers were involved in the political elections, and they have a direct interest. And they have also taken part in voting for this posting of mail arrangements. So I think there is a declaration of interest. My former assistant has lodged a complaint to the LAD on this, but his request has not been responded to. Can I be given an extra minute, Madam Chair, to speak, to finish what I have to say? The applicants have a choice in the use of language in the litigations. Some barristers, are not heeding to the preference of the applicant because they want to cut favor with the judges. And the LAD is also allowing these barristers to use language which is not familiar to the litigant, and that's very ridiculous. There is another point that I would like to raise on the section about comparison with overseas jurisdictions mentioned in the paper. I think the information is very superficial. For some jurisdictions, they don't cover personal injuries and matrimonial cases in the legal aid scheme. But is it the case that there are other systems, social welfare systems, may be helping out with these cases? In New Zealand, the New Zealand government is cutting on judicial aid services, and it is heavily criticized by the barristers in New Zealand. Sorry, Mr. Raymond Wong, your time's up. The government must give more detailed information in the overseas jurisdictions. Well, Mr. Raymond Wong, you have prepared a written paper and you want to finish reading it out. Including myself, there are 5 members who are queuing up to speak. So perhaps I will not give the time now to the administration to respond. You can perhaps respond, give us a consolidated response later after all the members have spoken. Next one, Dr. N. Zhang. The LAD has certain responsibilities, and they must ensure that public funds are properly spent, and there will not be abuse of the system. Mr. Raymond Wong mentioned about these 2 recommended lawyers. They came from the same political party, and they were dealing with political elections. I think this is something that we must follow up. How come that such recommendation was made? Is it that there were only 2 lawyers in Hong Kong who are familiar with political elections? I don't think we can't let them off on this case. I think we should pursue the case and ask for an explanation from the LAD. Perhaps they can give us a written reply later on. And then I would also like to mention that in the past several years, has there been an increase in the number of cases handled by the LAD? From this paper, I don't have any figures on the number of cases and also the amount involved. I would like to have some figures, the statistics. And also for applications for legal aid, I would also like to know how many cases have been rejected. What is the percentage in the overall number of application cases? I would also like to know that in the past 3 years, under OLEX, well, how much money was spent on OLEX and how much on SLEDs? The respective amount of money spent on these 2 schemes. And also, I know that under OLEX, the FEL is 269,620 Hong Kong dollars. And for SLEX, and it's $1.348100 million. I have received some views from members of the public, and they said that their applications for legal aid have been rejected, and they later on have to sort of pocket their, they have to pay for the expenses. And their personal asset is above that $1.3 million limit. Now, after the litigation was over, and he had to pay for the litigation costs, and after paying that amount, his income or his limit has dropped to below $1.3 million. And the LAD told him that, well, because he has exceeded the limit before, then he could not come, even if his he has fallen below that limit now. But can you review the situation, because he have already paid the litigation costs and his assets has fallen below $1.3 million. Can you not consider his case again, if that is the case? We know that the legal aid is to help the aggrieved persons, and they may be suffering losses. I think the legal aid department is right in doing that. I would like to know that in recent years, under the Hong Kong Bill of Rights Ordinance, Cap 383, and cases which may be breaching the provisions of the ICCPR, well, what is the number of cases received by you in relation to these two documents? Has there been an increase in the number of such cases? Well, I know that there have been judicial reviews. There may be one individual who is constantly seeking judicial reviews. I think this is very problematic. But anyway, I would like to know whether there is an apparent increase in the number of cases in relation to the Hong Kong Bill of Rights Ordinance and the ICCPR. All right, please. I think a lot of the questions have to do with the implementation of the ordinance of the LAD. Perhaps I will hand over the time to the director to take the questions. Well, I'll start with responding to the Bar Association's remarks, and then I would answer members' questions one by one. Mr. Guy Barretto just now referred to the SLAS. We are in the process of expanding the scope. What I want to say is that the LASC is actively considering an expansion of the scope. The working group, the chairman, is a representative from the Bar Association. And I believe that we all welcome the Bar Association's views. And these barristers have participated and given views to the LASC in that aspect. And also Mr. Perry mentioned about there are a number of cases without legal representation. I would like to clarify. Well, it might not be appropriate to use a percentage to look at the situation. Perhaps we should look at the absolute number of cases rather than the percentage without legal representation. Now, for cases without legal representation, they might not mean that all of them, their applications for legal aid have been rejected. For some of the cases, the litigants have never applied for legal aid. And also in criminal law, if the applicant is denied of legal aid, and if in the case of appeal, the case in the Court of Appeal can actually grant legal aid to him immediately. I mean, there have been examples of that before.
唔好意思，邝處長，因為我哋每個議員有佢時間，咁可能咧，你哋再要補充嘅兩位呢，我哋真係要俾其他議員，大家都要合理，大概7分鐘。係。啱啱咧我就講到5分鐘嘅，咁停咗啦，又跟住咧阿處長咧就回應，係回應。
And then the director responded to the Bar Association, but the clock is still ticking. Ms. Jiang, I will give you back your time, but I will have to ensure that all our members have a chance to ask questions. So please respond to members' questions first, because this is within the 7 minutes of the members. So please respond to members first. Later on, you will be given some time to give other responses. So please be more focused. We have to work according to the time. So can you respond to Ms. Cheung's questions first? Yes, Madam Chair. Sorry, I didn't do that. So for Ms. Cheung's question, just now, Mr. Wong mentioned a case And that case was given to Mr. Albert Ho's law firm. I'm sorry, I don't think I should be talking about individual case information, and I also do not have the information in hand. I'm not sure what it is. But I know that, well, for all the applicants, they have their right to choose their own lawyers. Now, we will not say that they definitely have to choose a certain lawyer, so they have their rights. And secondly, Ms. Chiang asked whether we can provide information concerning the applications rejected. And also, how much money have we spent on OLAS and SLAS? That is okay. After the meeting, I will provide the relevant figures to you. And also, you mentioned another case. You said that was this applicant, and his asset exceeded the FEL when he made the application. And then after litigation, he lost a lot of money, so he didn't have as much assets. And actually, if he was eligible at that time, the LAD should approve his application. I think there's some misunderstanding here. If he meets our FEL, we would definitely offer him help. As for Bill of Rights cases, lately there has been no increase in application in this regard. I think our members will follow up on some of this. Just now, Mr. Kwong said that, well, some people may not have applied for legal aid, and he shouldn't be talking about individual cases. Well, I think that members have asked very reasonable questions. The case, as seen by a third party, should be fair and just, and there should be no conflict of interest. And these principles should be upheld under the common law. So I think you have to further explain to the member. You cannot just say that you do not have the relevant figures. So let us ask the other members to raise their questions. Mr. Dennis Kwok. Well, Chairman, I would like to declare my interest. I'm also offering legal aid to people. And just now, you've been talking about the reform of SLAS. Before I became a LegCo member, the Bar Association had already been talking about this. For example, can SLAS cover different claims? For example, hazard claims. How come it took the working group such a long time? In paragraph 10, the working group has been mentioned. I think it's really been working very, very slowly. So I hope the director can respond to this. And also, another member talked about the choice of lawyers. Actually, it's not mentioned in the paper. Article 33 of the Basic Law allows Hong Kong people the right to choose their own lawyers. It's not mentioned in the paper. This is very important. How come the paper is silent on this? No matter what, I hope the director can respond to me about the work of the working group. Well, when can it come up with a conclusion, and what is the working group looking at? I hope you can explain to us what the working group is doing in this aspect. Thank you. As for the LASC's working group, now its consultation is nearing the end. So, but I cannot speak on behalf of them because it's a group under the LASC. I've heard that they've received a lot of opinions. I'm sure it will not take them too much longer for them to come up with a conclusion. I hope this panel can officially ask the LAD to do this. That is, the working group should tell us exactly what they are doing. They should give us a status report because they have been doing this for 2 years. When can we have an answer? We have been talking about legal aid for N times. When can we get an official reply? Before I became a legislator, I was sitting on the other side, and I was listening to the same thing. They were telling us that there will be reforms, etc., but we've been waiting and waiting. I hope our panel can officially ask the working group to give us an answer in writing, and then we will follow up. Can you do that? How about a progress report, Director? Shouldn't the Bureau answer us, Mr. Low? As the Director said just now the working group is doing its work and now is nearing the end of its task. I think a pragmatic way of doing it is for us to communicate with the working group and ask whether they have recommendations ready now, or can they give us a progress report. Yes, I understand that members want to know earlier what the result of their discussions is. So if there are recommendations, I'm sure members want to see them as soon as possible. But if it will still take some time to come up with recommendations, I hope they can give you a progress report. Chairman, if they haven't put together recommendations, well, at least now you say that it's nearing the end of their task. So in 1 or 2 months' time, at least they should give us a progress report. And then later on, we will talk about their recommendations. So at least we should have a progress report. I'm sure that can be done. Is my understanding correct? Yes, I understand what you mean. I'll talk to the LASC. Just now we talked about the coverage of legal aid. Now there are a lot of litigants who are not legally represented. Lately I've seen a number of figures, and High Court, this exceeds 50%. That is litigants without legal representation. This is very serious. You know, now for the waiting, for the High Courts, the waiting time is very long. In the Court of First Instance, there are now 10 vacancies for judges. So the waiting time is getting longer and longer. And there are so many litigants without legal representation. So you can see that the pressure on the judiciary is very high. Legal aid plays a very important role. I hope the Director can look at the judiciary's present situation when you consider any reforms. Director, thank you. Yes, I understand, Mr. Kwok, because I'm also sitting on the Civil Justice Reform Committee. And without legal representation is something we are very concerned about. We will continue to communicate with the courts and try to find out why there are litigants that do not have legal representations. Is it because of the scope of the legal aid or what? So we will continue to talk to the courts. Next, Mr. Tang Ka-piu. He's not here now. Next, Mr. Leung Kwok Hong. HAB is the bureau responsible for LAD. I think this is not an appropriate arrangement. This is illogical because the Secretary for Home Affairs is not specialized in law. And I think if the system is to be reformed, it should not be spearheaded by the HAB. And secondly, what's the foundation of the rule of law? If somebody doesn't have the money to hire a lawyer and he knows that he's not as smart as a lawyer and it's impossible for him to defend himself, then the rule of law will not be upheld. So a lot of resources must be used to do this in society. We respect the judiciary and judges. We put a lot of resources there. And if the rule of law is to be upheld, more efforts must be made so that there can be fair litigations, because a child cannot fight with an adult. and a 4th division football club cannot play a 1st division football club. Just now, Ms. Zhang has talked about some cases, and if it enforces the Hong Kong Bill of Rights Ordinance, the litigant should not be asked to pay the cost. In Hong Kong, we have the basic law as a constitution. The constitution provides protection to our people. And the basic law has not been in existence for a long time, so we do not have a lot of case laws. So I don't think the courts would have enough experience in dealing this. This is not like lecturing in a university. So I think more comprehensive support should be provided by the government. I have sought judicial review about filibustering because Mr. Jasper Zhang ended my filibustering. But I had to pay for my judicial review, and I spent over $600,000 on the legal cost. I hired my own lawyer. Well, we should have the 3 independent powers in our society. Our president uses public funds for that judicial review, and a legislator challenges the president, and the legislator has to pay his own bill. So I think you also have to look into this. You cannot just copy from the UK. Our CE is almost like a president, and we have our own constitution. In our constitution, yes, the 3 powers should be separated. However, there has never been a court case on this.
As for the FEL, I don't agree that the family members' income should be included. Well, the basis of the rule of law is that everyone is considered a separate individual. So how come the family members' income is also included in the overall eligibility test or means test? I think only the individual's income should be included and not the spouse's. Well, the wife's income should not be included, in my view. We should respect the rights of the individual, and we should not take family as a unit. In the history of fighting for human rights, we've been trying to fight for the rights of the individual. How come we are taking a reverse approach here, including the family members' interest? Administration, Mr. Low. Mr. Lang referred to whether the Home Affairs Bureau should be the Policy Bureau of Legal Aid. In June last year, at the meeting of the same panel, we did discuss that point, and the administration has already explained to members that the government has agreed that the legal aid portfolio will be moved to the Chief Secretary for Administration's office. There are 2 points that I would like to make. There will be this removal exercise, but we will not be sitting with our arms folded, not doing anything because there is this removal exercise. We will still be studying on the expansion of the coverage of the SLAS and so on. And in this interim period, we will discuss with the relevant government departments on how to set the priorities and how to actually implement this removal exercise. On the operation of the schemes, I'll defer to the Director. Thank you, Mr. Leung, for your question. First, I would answer about the cases related to the Bill of Rights Ordinance. And according to the law, then I have the discretion of waiving the FEL. I do have that power. And Mr. Leung also referred to a judicial review case. I didn't have the information on hand on particulars of the case. If the case has nothing to do with the Bill of Rights Ordinance, the contribution is not to exceed $600,000 for judicial review cases under OLAS, not relating to Bill of Rights Ordinance. So the highest contribution is $60,000 and not $600,000. There may be some misunderstanding here. And Mr. Leung also talked about the Bill of Rights Ordinance cases and judicial review cases. Should the contribution part be waived altogether? I think this is quite difficult to implement. Of course, I understand that human rights are very important. But then, say, in matrimonial cases, no, the people may think that chasing after maintenance orders is very important. Also, in an industrial accident case, the family members will find that, well, the compensation is also important. So if we go by your suggestion, then does it mean that all these other cases, there should not be any contribution from the applicant as well? So this is something that we have to consider. Everybody thinks that their cases are important. With regard to the vetting of the financial assets, we will also take into account the applicant's spouse's income and assets and so on. And because in most of the cases, when the applicant gets damages in the end, the spouse will also benefit. And also in legal aid schemes worldwide, they are also adopting this household income approach for calculating the eligibility criteria. So we're no different from other jurisdictions in that regard. Mr. Albert Ho. Next. Thank you, Madam Chair. This panel has all along been very concerned about legal aid. We discuss this topic every year, almost every year. The Bar Association and the Law Society have given a lot of views in the past, and regrettably, the government has been dragging its feet. And in a number of cases, because of the limited coverage of the legal aid scheme, the individual's rights are being forgone or not being exercised properly. For example, for the SLAGs, it is a self-financing scheme and no public money is involved. Well, in that case, I don't know how come that you cannot expand the scope. Actually, in many of the cases, after the merits test, a lot of cases are found to be having reasonable grounds. So I don't understand why you have not been progressing fast on expanding this SLAS. And I agree with Mr. Dennis Kwok that there should not be any more procrastination. There should be a timetable given to us. I have to declare that my solicitor's firm is involved in legal aid cases, and some colleagues have queries on whether I should be involved in that work. Well, is it simply because that I am being a electoral member, then I should not be involved in a lot of things? Is it the case that, say, some legislator from the engineering sector, he should not be involved in engineering works at all? So I don't think that's reasonable. But anyway, I agree that the LAD should deal with the cases fairly, and there should not be touting, champerty, and they should work together with the ICAC and look at individual cases and make sure that the lawyers assigned are properly assigned. Now, for any litigant, it should be his right to appoint his own lawyer, and that is enshrined in Basic Law Article 35. And we all know that the trust between the litigant and also the assigned lawyer is so very important. And also the solicitor's firm and the associated barrister, whether they have the relevant experience, that is also important. Some colleagues said that certain barristers or solicitors have certain political views and they should not be engaged in any legal aid cases at all, and they may have conflict of interest. I don't think that's right. That's a fair remark. Please do not make remarks like those. I think there should be an independent body, for example, the ICAC, or some third party in the legal sector, to look at whether they do have a declaration of interest. If you say people who are engaged in politics can't do certain things, then I think that's not reasonable. Well, I think we have to go back to the basic right of the litigant. That also, the scope of the legal aid scheme, I think that's also an important part. Libel cases, well, that were originally outside the scope of legal aid. And actually, a lot of people are involved in libel cases, especially, for example, people who are in the owners' corporations of a building, while certain individuals are involved in libel cases. And many of the defendants have very good defense grounds, but it's just that sometimes they don't have legal aid and they don't know how to protect their own interest. Many people's rights are now being deprived. Even if you have legal aid, that doesn't mean that the litigants are in an equal position as the other party. For example, if you are up against a property developer, the counsel for the property developer may be very, very sort of different or superior to the lawyer assigned by the legal aid department. But anyway, it's good. Ultimately, in the end, it's better to have a legal representation than not having legal representation. And also because without legal representation, there has been a waste of the time in the court, because the judges have to, say, explain to the litigants a lot of the basic knowledge, and that represents a waste of time in the court. So I think the administration should conduct a study on the time, the necessary time spent by the litigants because they don't have any legal representation, and that means public funds as well. Well, the legal sector is short-handed now, and the quality of the proceedings is also not very good, because some litigants come without legal representation. So I think these are all factors that you have to take on board. Mr. Raymond Wong and Dr. N. Zhang, as I understand, what they're saying is that the legislators should not be involved in any court cases, especially we have a declaration of interest system, that should be okay. Mr. Raymond Wong, his question is this. Well, he mentioned about your name, Mr. Albert Ho, and And the case was against the major political parties, not just your party, also the DAB as well, because you are one of the parties in the case, so that might be problematic. So it has nothing to do with whether legislators can take on court cases. These are two separate issues. I think this is what they meant. That's my understanding. So perhaps, Director? Oh, I don't see the logic there. Deputy Secretary, several members, including Mr. Ho, referred to litigants without legal representation. The Director also said just now that if litigants in certain cases don't have legal representation, well, you can't really draw the conclusion directly that they are without legal representation because they couldn't apply for legal aid. In overseas jurisdictions, they have also given us views that there may be certain other reasons rather than just having no legal aid. Perhaps the litigants chose not to have legal aid, or they didn't pass the merits test. But then I would also agree with you that if there are too many litigants without legal representation, lacking legal knowledge, and that would add to difficulties of the proceedings, and that would take up more time. With the support of your panel, actually, in 2013 March, the HAB launched a pilot scheme to provide legal advice to litigants without legal representation. This is a pilot scheme that has to do with civil proceedings, and litigants without legal representation under that pilot scheme can get free legal advice from the government. According to information on hand, since the launch of the pilot scheme up to February 2015, we have helped 1,180 litigants without legal representation. And we have provided 3,400 sessions to them to provide free legal advice to them. We have asked those who have been on the pilot scheme to seek their satisfaction level. Over 90% of such litigants said that they are satisfied with this service. So this is a pilot scheme, as I said, and we have established a steering committee chaired by Mr. Pan Kin-kay, the former High Court judge. The pilot scheme has been up and running for 2 years, and in the near future, we will be reviewing the effectiveness of the pilot scheme and then make further recommendations to the government.
Next, Mr. Lam Sing, Chairman. With regard to legal aid, I believe is also a concern of the public, and as legislators, we should also monitor how public money is spent properly. Just now, some members asked whether there have been charity activities. Of course, these are also our concerns. Lately, we have seen many judicial review cases, and there are some people who always seek JR. Some political parties or organizations would join hands with these people who always seek JR, and they also would cooperate with certain lawyers. So these lawyers would always represent There's people who seek judicial review, and they're always against the government. Now, there are a lot of arguments at the logical. It seems that we are always trying to stand on moral high grounds. We do not want to be accused of using public money for a certain side. In Hong Kong, people have very different political views, and there are always disputes. And now you provide legal service to the people who share your views, and then you seek JR together. So does it mean that when they win the court case, you will get the money, and if they lose the court case, you do not charge them? So I would like to ask the government how it has been spending public money. Did any lawyer agree to certain conditions when they take up a case? Do they get any benefits? And did anyone follow up? Does the government have any information in this regard? And will you follow up on special cases like this? That is, a lawyer will join hands with an applicant, and then a lawyer will be assigned to that applicant. And after a case is won or lost, have you seen any problems? So have you followed up on any of these? Director? Thank you, Chairman. When the LAD received an application concerning JR, well, actually, when we look at the past cases, we haven't seen anyone like this. That is, the applicant had any agreement with a lawyer before coming to the LAD. Last year, we launched the mechanism for making representations. We also want to clamp down on this. Now, if there is any conflict of interest on the side of the lawyer, then he should follow the assignment conditions, and all the documents should be returned to us, even though that law firm is given that assignment. And when an applicant chooses his lawyer, he must declare that he doesn't have any prior agreement with the lawyer and is out of his own free will that he chooses that lawyer. So this is the mechanism that we launched last year. Just now, we also mentioned that the ICAC and the LAD have already formed a corruption prevention group to look at our assigned out cases. So they have given us recommendations, and we will enforce their recommendations. Yes, I think a reasonable mechanism has to be set up to make sure that public money is spent properly. And for the LAD, when it comes to the choice of lawyers, in the future, would you adjust your arrangements? Shouldn't the LAD be given the power to choose the lawyer? I think there is one thing very important. In accordance with Section 13 of the LAO, the applicant has the right to choose his own lawyer. We have been reviewing some cases. We have turned down the choice of certain applicants. Well, in such cases, is because such lawyers had a bad record with us, or is a lawyer that's already handling too many of our assignments. So under such circumstances, we have turned down certain applicants' choice. But of course, we have to exercise this power very carefully, because in the AO it is stated very clearly that an applicant has such a right to choose. And if the applicants cannot cooperate with the lawyer properly, then of course the case will be affected. So the LAD, well, in the future, can you work in a more transparent manner? That is, when it comes to public money, I hope that more figures can be made public and your whole task work can be more transparent. Next, Ms. Scott. Well, lately we have seen many JR cases, and many of these cases involve legal aid. Members of the public are very concerned. Now, we have to ensure that the lawyers will not share the damages or properties that they get after a proceeding. But many people are now applying for JR, and then they can choose their own lawyers. Then for the lawyers, they know they will get this kind of business. So this is quite obvious in JR. For many of the JR lawyers, they are friends of the pan-democratic camp, or they are pan-democrats themselves. And many of these JR are about major infrastructure projects in Hong Kong, and the result will have a huge impact on Hong Kong's future. So how can we prevent an abuse of the assign out system? And how can you monitor the situation? Director, I think there is one thing very important. Even though it's not in JR case, people may also seek legal aid because they do not have the means for litigation. And when they come to apply for legal aid, they have to pass our tests. For example, one of the tests is that whether there are reasonable grounds or points of law involved. And also they have to meet our FEL. So the existing mechanism is very adequate. If the applicant has reasonable grounds, he has the right. So we would definitely pay attention to that. We are very careful with all the cases. So that's why now we have a declaration mechanism. When a law firm takes up a case, it has to ensure that there is no conflict of interest. After taking up a case, if we discover that there is a conflict of interest, the committee that I chair will consider whether that law firm can continue to serve us. What do you mean by conflict of interest? Can you clarify? So if a person is seeking JR, for example, if he wants to turn down the decision of a LegCo, then what will you do? Well, when we see a case like this, well, if a lawyer is just thinking of his own interest, and if an applicant is deprived of his own free choice to choose a lawyer, then we would be very concerned, and that would be considered a conflict of interest. So sometimes it may not be just about JR. For personal injury, there may also be improper touting activities, and we would also see conflict of interest in that area. I just cited some cases. Of course, the public knows what is meant by conflict of interest. For example, if there are some government projects and this government project has been approved by the LegCo, some opposition parties object to this project, that the opposition party encourages a person to seek JR so that this project can be turned down. So do you regard that as a conflict of interest? I think this is a political question. The LAD would look at the merits of a case. If there are no merits, then or no reasonable grounds, then we would not grant legal aid. For example, if a political party objects to certain funding for a government project, and if it fails to do that at LegCo and it makes use of JR to procrastinate the project, that would meet interest for that political party. So this is a gray area that you should review. Director, would you review that? I think it's very difficult for me to answer this question. It's just a conjecture. I don't think so, because we have seen many cases like this. And if you cannot give me an answer today, I hope even the chairwoman will ask you to conduct a review. We still have another round of questions. We have a second item on the agenda, which is less controversial. However, legal aid is something that we are very concerned. So that's why we have a second round of questions, and we'll give the government enough time to respond. In particular, responding to the Bar Association and the Law Society about the timetable. We would also allow representatives of the Bar Association and the Law Society to speak for another round, so we will give you enough time. Let me ask my questions first.
On the question of legal aid, it is very important to the rule of law. That means those without the means can still have access to justice. I think this is an issue of great concern to us. So since 2009, when I joined the LegCo, my first motion proposed was to increase the legal aid service or level for the middle class groups, because they have often been in a plight. Now, 5 years prior to that, before I joined the LegCo, I've received views from the legal field and also those applicants who have applied for LA legal advice, and they've given me their views. And recently I received this letter, well, such letters, or rather, some, well, cases related to Bill of Rights ordinance. The applicants' FEL may be waived by the director. Legal scholars have applied for legal aid because there is language discrimination on the use of language, and you told them that that has nothing to do with human rights, and because he taught in a university, of course he was above the FLEL. That point has been also mentioned by Mr. Raymond Wong about language discrimination. So how many cases are there where the FEL has been waived because these cases are related to human rights? Second issue, the vetting period. Well, the society has become divided after the occupation movement, and they said that the LAD has been processing quickly the cases related to occupation movement. But for other cases, the vetting period takes longer. So are you taking into consideration political considerations when you do the vetting? Thirdly, a lawyer has given me this view. Legal aid has to do with public money, and it's not a matter of scarcity, but rather uneven or unfair distribution. For some legal aid cases, they have been assigned to certain solicitors' firms and not others. I think we have to look at whether the lawyer concerned is related to the cases concerned, and also the judicial review cases. Many solicitors actually have a wealth of experience, but they've never been assigned cases by the LAD. In the appendix, you said that for solicitors, 45 cases in 1 year, that this is the limit. For counsel, is 25 cases within the past 12 months. Well, if you have experience in litigation, you know that one case can last several months. So, in effect, there is no limit, I would say, by that kind of standard. And actually, in the legal profession, a lot of lawyers would like to take on legal aid cases. You've been criticized for assigning certain types of cases to only a handful of counsels or solicitors. Can you share with us the information? There is also a condition of stay case, legal aid case, that took up, say, some $40 million, and that is very costly. But for the grassroots people's cases, the vetting period seems to have usually take 3 to 4 months. And also, they have difficulties in comprehending the language of the litigation. Have you done anything to help them? Are you using your public funds fairly? Are you concentrating all your resources on certain cases like judicial review cases, and then you are dragging your feet on other not so important cases? There is another question that I've been following up on. And mainland Hong Kong person on the mainland involved in cases. Well, I've recently helped a case. This person was living on the mainland for 11 years, and he was jailed, and he has recently been released. But he is a Hong Kong person involving a court case on the mainland. Can't you offer some advice or help? Well, at least you can provide some preliminary advice, well, say for your pilot scheme on free legal advice for persons without legal representation. Can you extend that to cover Hong Kong people living on the mainland? I think they're in a plight, in a predicament. They are usually from the middle class. So can you do something to help this group of Hong Kong people living on the mainland and involved in litigation? The last question first. Well, our legal aid system focuses on local courts in Hong Kong. So Hong Kong people involved in litigation in other jurisdictions, I'm afraid that they are not covered under the legal aid system. And we don't have any plan at the moment to expand the scope of to cover overseas jurisdictions. I hope that you can review that. Director? Madam Chair, thank you for your questions. I will try to answer them one by one. First, you mentioned about a case, the academic involved in court case in relation to language. Well, we've provided the legal aid to the applicant, and now even up to the stage of appeal. No, I don't think so. The case was in 2002. Well, from my records, I did see that the legal aid was provided. Anyway, I'll go back and check. You also mentioned about the vetting period of applications. We would not deal with cases particularly fast when there are political issues involved. What we look at is whether this is a pressing case. For example, the litigation will be very imminent, then we will deal with those cases expeditiously. For occupation movement cases, have they affected the time spent on other cases? No, that has no effect at all, because different colleagues are taking on different cases. In the past 12 months, we have a limit, 45 cases within the past 12 months for solicitors and 25 cases within the past 12 months for counsel. The limits were drawn up after consulting the LASC and also the Bar Association and the Law Society. We're talking about 12 months, a period of 12 months. The limits on cases, 45 cases within the past 12 months. Some of the cases may be rather simple matrimonial cases. And actually, for some cases, the litigants don't have to be appearing in court. So at that time, we think this number 45 is rather reasonable. And for civil cases, the solicitor can assign the case to another solicitor in his firm. So we think that the 45 cases is a reasonable number. Do you think that is still a reasonable number? We've received a number of complaints saying that is not a reasonable figure. 45 cases. I don't think that's fair and reasonable. I hope that a review can be done. These are the views that we have received. All right, the second round of questions, Mr. Dennis Kwok. 3 minutes, please. Madam Chair, you've spent 9 minutes yourself. I hope that I can be given more time. Many members have talked about the legal aid for judicial review cases. I must stress again, based on my experience, the LAD councils are very reasonable and neutral in their stance in dealing with JR cases related to human rights. They are political neutral in dealing with these cases. That's my experience with them. You have to consider the applicant's political stance and so on. I don't think that's an acceptable way of life in Hong Kong. I don't think LAD should take into account those factors. LAD, in dealing with applications, they would first see whether there are reasonable grounds in the cases. And if they are not clear whether there are reasonable grounds, under the LAO, the director can seek a Section 9 opinion from third party, from the legal field, to advise him whether there are reasonable grounds for the case. And if the answer is affirmative, then the LAD will take forward the processing of the case. If the opinion is in the negative, then the LAD will, based on the external legal advice, not approve the legal aid application. And also, in judicial review cases, the court also has a mechanism to ask the JR applicant to present reasonable grounds before a leave application is granted. I think this is a very rigorous process. The judge will attend to the matter himself and would also invite the government representative to state and present to make representation. So after the leave application is granted, then the applicant can take our judicial review. So this is the mechanism we are seeing today, and I think that the mechanism works well and is sufficient. Say, on the contrary, if a person has reasonable grounds to take someone to court, then we should allow him to do so. Now, with regard to the choice of lawyers, Article 35 of the Basic Law provides that this free choice of lawyers for individuals. Do you want to take out that right? You can ask for amendment of the article. I don't think that's what you meant. And lastly, we are discussing this new proposal about the declaration system. On the 23rd of August 2013, the Legal Aid Department, or rather the Bar Association, has given you a letter, and you sort of rejected the Bar Association's suggestion of revise the wordings of the declaration form. Please answer to the Bar Association and tell us why their proposal is not acceptable. Do you think the present mechanism is sound enough? I would let Mr. Stephen Ho ask his question first, before we ask the administration to give a consolidated reply, and then we'll have the Bar Association to speak again. Mr. Stephen Ho. Madam Chair, I haven't heard the answer from the department clearly in relation to your question. You said that there are different ways of dealing with cases related to the Occupy movement and those which are not related. Are you talking about different people, staff members, or what? And also, people have the choice of the lawyers, I understand. Now, at the illegal occupation movement during that period, there was this voluntary team of lawyers. Of course, they supported the movement, and some demonstrators were facing criminal litigation. And how many of them have applied for legal aid? Now, this group of demonstrators will also be choosing their own lawyers from this list of voluntary team of lawyers during the occupation movement. How many of them are doing so? I would like to have some figures. When we dealt with cases related to Occupy Central movement, they were not given any special consideration. So that's why I said their cases will not affect other cases. Now, as regard the figures, how many cases of legal aid application related to Occupation Central movement? I don't have the information on hand. However, as far as I remember, there were not many cases like this. Now, even though there were just 10 or 20 cases, how many of them have chosen lawyers from the team of voluntary lawyers? If it's 100%, then there would be a conflict of interest, because these people encourage people to break the law so that they can do business. This is my point of view. I need him to answer. I think I'll go get the information first before I can answer your question. I would also like to ask some questions concerning figures. I think figures can tell us a lot of things. Please give us these figures. That is for independent barristers' advice. Are they always the same barrister or same type of barristers? We need to know the list. You say that you have sought independent barristers' views, but some people have complained that how come for their cases no independent barristers' views have been sought. So please give me a name list. Which councils have you asked for third opinion?
And also for the expenditure of legal aid. If it's the same law firm or a law firm is handling more than one case from the LAD, do you have this kind of figures? Please give us the figures. And how? So I would like to get all these figures because this would help us to monitor, because legal aid is using public money, and lately there have been much concerns in this area. And we all know that we have the right to choose lawyers. However, because now you have a system, and people have been talking about public hospitals. Sometimes you would only send junior doctors to handle certain cases. So it is the same for a law firm. You do not need senior counsels to handle the cases all the time. So I think you need to review all these figures. So please give us the relevant figures, and then we can use this as a basis for assessing your work. So are you lopsided towards certain cases or certain law firms? How about the number of civil proceedings, criminal proceedings, etc.? We need all those figures. Next, we would like to invite the representatives from the Bar Association to make a final speech. Mr. Barreto, will you be doing that?
Yes, we agree with the Director of Legal Aid and Dennis Kwok that by law, Legal Aid Department has to be political neutral. So the assertions that we've heard today are rather disturbing. They process cases based on the facts and the law. That's the merits and the means. That's a statutory obligation to ensure matters are dealt with properly. And the political posture of anybody on either side is completely irrelevant. There's no possible conflict of interest or grey area here. Second matter I wish to respond to is this declaration system. Now, that is an area for improvement. As Dennis Kwok said earlier, there was an exchange of correspondence between the Bar Association and the Legal Aid Department back in 2013. The Legal Aid Department provided us on the 14th of August with their suggested conditions of assignment for panel lawyers, which were 3 conditions. It said this assignment is made on conditions that 1, 2, and 3. And we responded quite quickly on the 23rd of August, providing an improvement of the 3rd paragraph to remove about 3 loopholes which we could see in the wording there. And then we received a letter a week later from the Legal Aid Department on the 30th of August saying that we won't amend the conditions, but we'll keep it in mind for review in the future. So I can just hand this letter these letters up to you just so that you have them in future. We would request that the matter be reviewed to see if you can remove these loopholes that we could identify then. It may be now that there are other loopholes which have been discovered, but at least that's a step forward to keep the work going, because obviously there seemed to be some concern today amongst different members about the need to look at the situation to prevent touting, and that's precisely what we have in mind, not just champity but touting and the possibility of agreements which many people today have been referring to and which we don't agree with, of course, at all. So we hope that will improve situations, but we'd like to open a dialogue on that. Next point, the SLAS scheme. The reform for this is totally dead in the water. I totally agree with Dennis Kwok that we need a progress report. Now, I'm rather concerned that what we're seeing is that the LASC, who are not here today, remarkably, on a particular matter which affects them, not one person from LASC has turned up. We're particularly concerned that LASC are now nearing the end of something, but we haven't been consulted for the last year. We heard nothing. So what's happening? Are they going to suddenly spring something on us and say, that's it, fait accompli, and then make a recommendation to the Chief Executive? Not acceptable, madam. We expect now to have at least a progress report and something that we can consider. Because we've seen some of the responses from the administration on some of the matters we've put forward over the last 10 years, more than 10 years. And we know that we can challenge some of the responses because there have been very feeble excuses for no expansion of SLAS in many cases. So we'd like to see this progress report, see where things are going, so that we can provide some constructive progress on this. Because we know this is not easy, but the length of time it's taken and the lack of comeback from the LASC is really not acceptable nowadays. So please, can we have a progress report and an assurance that we'll be consulted properly and adequately to take this forward in a constructive manner. The
Any more?
I think we note that the legal aid department is being transferred from one bureau to another. That shouldn't be a reason for any further delay in any of these matters. I'm just trying to see if there's any other matters we need to pick up on. Madam, I think those are the matters which we're really concerned about.
Okay. Thank you, Mr. Barreto. Yeah.
Why aren't the representatives of the LASC here? Have they not been invited? I can't hear you. I think we have not invited them. I think we need to see them. I remember Mr. Li Ka-sheng was here representing the LASC when we had meetings before. Just now, Mr. Barreto was right. The Bureau said that there will be a status report. Well, this is unfair to the director. How can I answer you? Yes, I think they need to give us a progress report. The panel will ask them to do so. Due to the time constraints, today I don't think we can talk thoroughly. Today we are focusing on this paper. So I think first of all we have to ask them for a progress report. We are all very concerned about the progress report. We will follow up on that. How about the representatives of the Law Society? Do you want to say anything?
Mr. Barreto, about the paragraph 3 of the conditions of assignment to panel lawyers, I think that the word chamber disagreement by itself is not clear. I think it should be particularized as suggested by Bar Association. The Law Society supports the Bar Association. And also one other point is there have been discussion about the number of cases. I noticed that insofar as civil cases, it's based on the number of cases. But insofar as criminal cases, it's not just the number of cases, but also the amount of the fees paid to solicitors and also barristers. I don't know why in civil cases we don't have a similar system. That's basically that.
Will you give a brief response to this? That is concerning the two legal bodies' views. In the paper, there are already details, so I'm not going to repeat them. As for Hong Kong's legal aid system, According to the paper, when it comes to the means test and its positioning, as well as the scope of the legal aid system, when we compare ourselves with other jurisdictions, I think we are quite favorable. And also, the LEF has been increased significantly. In 2012, we also expanded the scope of OLAS and SLAS. And now we are looking again at the scope of SLAS. I think we are looking at things from a pragmatic angle. I think we have been doing quite well, and we are just trying to make more improvements. As for the details you mentioned just now, I don't think that's enough time for me to talk about them right now. Director, I'll exercise my discretion. This meeting will be lengthened by 15 minutes, but after 6:30, we will definitely start the next item. So, Director. Thank you, Madam Chair. Just now, I heard the views of the Bar Association concerning the declaration system, and also the Law Society supports that. And the year before last, when we launched the system, Law Society had a different view from that of the Bar Association. But now they agree that there should be such an amendment to the wording, so we will definitely look into that. We would like to thank the two bodies for their views. And just now you mentioned cost for criminal proceedings. We already have a group looking at this, and later on we will be reporting to Elacho again. I think this panel agrees that you should give us a progress report, and members have asked a number of questions concerning figures. So please give us those figures in writing so that we can follow up. I would like to thank the Bar Association and the Law Society for attending today's meeting, and would also like to thank the relevant government officials. So please give us the reference information and figures in the future. Can you give me a minute? I would like to respond to Mr. Wong Yuk-man's question. I think there was some misunderstanding there. Please give me 30 seconds. Point number 1. He said that for the means test, we must get documents as proofs. That's not true. A lot of means can be used. Now, if a person can prove that he's supporting his parents, even though there are no documents, we may still accept that. And also, for means and merits tests, they are conducted together. It's not that you have to pass the means test first before we start the merits test. So the means test would not delay the progress of the case.
The choice of lawyers, the language that he chooses, and I think the ultimate choice of the language for the court proceeding rests with the court and of the judge and not the applicant. Thank you very much. You may be excused. Let's move on to the next item, and that is the subsidiary legislation relating to privileges and immunities conferred on consular posts. Paper number CB bracket 4505/1415 bracket 01. And the paper's heading is subsidiary legislation relating to privileges and immunities conferred on consular posts. This is a piece of subsidiary legislation and it has to do with privileges and immunities. And that is falls outside the jurisdiction, legal jurisdiction of Hong Kong. If members are interested, then you can raise your questions. Well, thank you. The Bar Association and Law Society representatives. Anyone wishing to ask a question? on this. So perhaps I'll ask Mrs. Doe to highlight the salient points. In February this year, we have issued this document to the panel, and which gives information on the granting of P&Is by the CPG to HKSARG, and also the progress of the HKSARG's preparation of the subsidiary legislation relating to the P&Is conferred on the Consulate General of Japan and its personnel. There are bilateral conventions between Hong Kong and other jurisdictions, and that is based on Article 18 of the Basic Law. So that has to do with the CPG regulation of PRC concerning consular P&Is, and that is also already in effect. Now, if the convention affects private rights, and also if there is another need to provide additional protection, then we will be drawing up local legislation to provide for that. We think this is an appropriate approach. The SARG will be drawing up an order on P's and I's in relation to the Japanese consulate, and we hope to have negative vetting in the second quarter of this year. So this is a brief presentation of the paper. So I would now like to take questions from members. Mr. Albert Ho. I have a question on para 11. It says that the relevant agreements are applicable to the HKSRI under Article 18 of the Basic Law, and then it goes on to talk about the CPG or the regulation of PRC concerning consular P&Is. Have they already taken effect in Hong Kong? Yes. Perhaps I'll take that question first, and then I'll ask the DFJ colleague to supplement. According to Annex 3 of the Basic Law and Document 5, the regulation of PRC concerning consular P's and I's are part of the nationwide laws applicable to Hong Kong. When did the regulation take effect? In accordance with Article 18, it should be 1997. 1997, after the handover. I find it difficult to understand at this point. There is this regulation, the national regulation coming into effect in Hong Kong and SARG. Does it mean that the consulate's immunities are given effect through this regulation? Perhaps I'll defer to the DOJ colleague to answer. Can you hear me? Yes. Thank you, Mr. Ho, for your question. The Deputy Director has made a clear explanation. In accordance to Annex 3, the regulation has already taken effect in Hong Kong. This time, we are signing this agreement between the PRC and Japan. And so, according to Annex 3, the regulations have already taken effect in Hong Kong. And we are obliged, therefore, to implement the relevant regulations. We are a common law jurisdiction, so we will be dealing with it in this approach, and that is if it has to do with private rights, and there is also an additional provision that needs to be added in, then that's still we have to have local legislation. So that's why this time around, this supplementary parts will be included in the subsidiary legislation that we are proposing. Perhaps I have not made myself clear. These are the bilateral agreements. And the regulations of the PRC concerning consulate P's and I's have taken effect, and it also applied to Hong Kong. I don't find any problem with the subsidiary legislation. I think that has to be done. It's in our diplomatic affairs. And I understand this because we have to protect the interest of the consulate posts in Hong Kong. The Ministry of Foreign Affairs may have representatives stationed in Hong Kong. Do they enjoy the P's and I's in Hong Kong? Well, if they do so, are they being covered under the regulations of PRC concerning consulate P's and I's? That may not be related to the subject we are discussing today. So the regulations have already taken effect in Hong Kong. So whenever the consulate's P's and I's are concerned, they have to do with national affairs. So we have to look at whether China has signed the certain agreements with the other state. Well, can I supplement on your behalf? I will try to wrap up the discussion as soon as possible. National laws. There are two ways in which they can apply. That first is direct promulgation, and the other is through local legislation. Whenever P's and I's of consulate posts are concerned, so if state government departments have representatives in Hong Kong, do they enjoy P's and I's? And we will have to look at the overall establishment in China. So it's not the case that whoever is stationed in Hong Kong belongs to the national establishment. So for these regulations, I think they should cover the establishment in Hong Kong. For some legislation in Annex 3, for example, nationality law, well, there is no local legislation. It is applies directly to Hong Kong. Well, perhaps I can follow up later on. The CPG's officials stationed in Hong Kong, how much immunity or privileges they enjoy? Which law gives them such privileges and immunities? Well, that may not have anything to do with the item to this. I think they belong to another establishment. So much for this meeting today. Thank you very much.